Good afternoon again, dear participants. We continue our program and invite you to join the second session of the conference, which is going to discuss the topic of decision-making in arbitration. For those who joined later, my name is Elena Privileged. I'm president of the Ukrainian Arbitration Association and head of arbitration at Integritas. I'm very glad to introduce our panel. Teresa Giovannini is a founding partner of LALIV. She has acted as counsel and arbitrator in more than 200 international arbitrations under various arbitration rules. Teresa is a Swiss member of the ICC Court of International Arbitration and performed various functions in other arbitration institutions and associations, and she is frequent speaker and lecturer on international arbitration. She has been also as been arbitrated and most responsive arbitrators by Global Arbitration Review. Our next speaker is Professor Catherine Rogers. She's professor of law at Bocconi University and has dual appointment at Queen Mary University of London, where she also co-directs the Institute of Ethics, Regulation and Commercial Law. Professor Rogers is a reporter for the American Law Institute's restatement of the U.S. law of international commercial and investor state arbitration. And among her research projects, Professor Rogers co-chaired the ICA Queen Mary Task Force on Third-Party Funding in International Arbitration, and she is founder of Arbitrator Intelligence, a global information aggregator and legal tech startup. Our next speaker is Marc-Henri, partner at FTMS Avocat, Paris, and president of the French Arbitration Association. Marc has been a lawyer in Paris for more than 30 years. He specializes in business litigation and arbitration and sits as arbitrator. His doctoral in law and his PhD work was about the duty of independence of the arbitrator. And he has strong doctrinal involvement and is lecturing in several master courses in arbitration law and the art of advocacy. We also have the fourth speaker, the Justice of Ukraine's Supreme Court, Konstantin Pilkov. Unfortunately, he has been called to join an urgent a hearing of the Grand Chamber of the Supreme Court today, but I hope he would be able to join us a bit later and participate in our discussion, but I nevertheless will introduce him now. So Konstantin is not only Justice of the Supreme Court, he's also Associate Professor at Kyiv National University for Trade and Economics, and Senior Research Fellow of the Scientific Research Institute of Private Law and Entrepreneurship, named after academician Burchak of the National Academy of Legal Sciences of Ukraine. He has PhD in law and master degrees in law and psychology. And before his appointment as a member of the judiciary, Konstantin was arbitration practitioner. He was also counsel and arbitrator and was listed by several arbitral institutions. He has PhD focused on matters of evidence of proof in international commercial arbitration, and as a justice he also authored several opinions that promoted arbitration. So with that, I suggest to go to our discussion, and we have a fascinating topic. So arbitral award is an end product of arbitration. And actually, this is the main reason, or one of the main reasons, why we refer the disputes to arbitration. However, how exactly the decision-making process works? This is a very complex topic, including both psychological and legal issues, and it could be addressed from different perspectives. So let's start from the arbitrator's perspective and with the topic of efficiency and integrity in the decision-making process, hurdles and suggested solutions. So Teresa, you are a very experienced arbitrator and have had hundreds of deliberations with co-arbitrators. Could you please share with us your observation regarding the decision-making process and related issues?
Thank you very much, Olena, and Hello, everyone. The one I see in the panel and the others I don't see, much to my regret. I would like to be in Kiev, but unfortunately, it is for later. I would like to, in the little time allocated to me, I will try to show that efficiency and integrity in the decision-making process is something which meets some hurdles, and would like to suggest some solution in that respect. Users expect the arbitration process to be both fair and efficient in terms of time and cost, which is absolutely normal and legitimate. And in that regard, as put by one of my learned colleagues, Swiss colleague, Dr. Berger, I quote, "From parties' perspective, you know the arguments and motions put forward in the proceedings, that is the input. You can see the result in the form of the dispositive section of the award, that is the output. And then you can try to understand the reasons given for decision in the award, that will be the transfer element. All the rest that may have happened in the deliberations remain undisclosed and undiscovered, what many call the black box." So let me turn to the unclosed element, the deliberations. Mr. Mosk, a very remarkable author, and I am sure Catherine is aware of, has written about deliberations of arbitrators and has written what follows. An important component of any dispute resolution mechanism involving more than one decision makers the deliberation, being recalled here that statistically a vast majority of international arbitration tribunals is composed of 3 members, a setting that constitutes the fallback rule in the UNCITRAL model law that has been adopted by many arbitration countries. Deliberations are held as mandatory in most national laws, as held by the French Court of Appeal. The requirement of deliberation is a fundamental principle of the procedure, which guarantees the judicial character of the decision reached by the tribunal, arbitral tribunal in that instance. The principle of collegiality assumes that each arbitrator will have the possibility of discussing each decision with his colleagues or her colleagues. So what is the problem? The problem is that this setting, which is very known and common in ordinary courts, it doesn't pose any problem within this kind of background, because all the judges belong to the same cultural and legal background. Conversely, deliberations in international arbitration tribunal have nurtured important debates connected to both the integrity of the process and time and cost involved. Why is that so? The answer lies essentially with the parties' right to agree upon any procedure for appointing arbitrators. And I think Professor Rogers will tackle this issue, and more specifically to choose their arbitrator, a fundamental feature in arbitration that is embedded in Article 11, for example, of the UNCITRAL model law, and in almost all modern arbitration laws and arbitration rules. And the result arbitration of an additional advocate of the views of the his or her appointing party. Bias has been said to be conscious or unconscious, tantamount to self-serving or egocentric interest, equivalent to misconduct. But little has been said to the most serious and most common bias, which is the cultural bias that stems from the differences in legal and or regulatory systems, nationalities, cultures, education, and backgrounds. Conversely, as I mentioned, the judges share legal background. And thus, for example, in the States, practice of partisan party-nominated co-arbitrator was historically common until 2013, for instance, where the AAA, the American Arbitration Association commercial rules, provided for presumptively different standards of independence and impartiality for co-arbitrators and presiding arbitrators, called tellingly neutrals. In certain European countries, I would not give any and not identify any countries, because it's not something to be ashamed of, but it's something belonging to a given culture. It's the party's appointed arbitrator role is understood in the advocating the party that appointed him or her. Different, if not opposite, legal approaches to procedure, adversarial versus inquisitorial, for instance, can also create this kind of cultural bias. What are the practical consequences of this cultural bias? is that arbitrator seeking to persuade a passive presiding arbitrator. Such negotiation, as put by my learned colleague Mr. Patoki, often leading to situations, I quote, in which one arbitrator is amenable to concur with another, provided that the point is conceded. I give you an example, which is very frequent. It's a mild decision on the quantum as a result of a clear and unanimous affirmation of liability, a situation that everybody is aware of. This bargaining process also triggers important consequences in terms of effort, time, and cost in the so-called discovery phase, but I will not tackle this time is too short. So where are there some solutions? This problem has been the subject matter of various debates and conferences. But as put by Professor Pierre Meyer, a learned authority in the field, I quote, the best way to arrive at a unanimous award, or at least to diminish the inconvenience of bias, is to start discussing the various aspects of the case rather early on, unquote. Along the same concern of avoiding bias, it has been suggested as early as possible in the proceedings, some suggest at the outset, that the arbitral tribunal plans and paves the way for how to approach the issues that will have to be resolved and the methodology by which the decisions may be accomplished. Others go further in advising that the points to be proven be discussed and identified at the first procedural meeting. Others still recommend that the issues, the real questions to be decided upon, be identified by the tribunal as early as possible in the proceedings. So how to identify the issues to be decided upon as early as possible, which is one of the solutions that has been argued and proposed. Identify, we have all of us gone through this situation where during the deliberations one of the arbitrator put forward a solution or an argument that none of the parties has thought about or even argued. And the second solution is that when this decision tree is set up amongst the arbitrator, is sharing the list of issues with the parties. This route requires that a very detailed decision tree be made, be elaborated at a time, where, as I said, where the dispute is in all its aspects put on the table. I would put that moment at a time where the written phase before the hearing is completed, and then that this decision tree be put to the parties for determination. The sharing of the decision tree with the party has proven to be very efficient. For instance, in a particular difficult situation of bias that has been reported by someone many of you know, Dr. Mark Blessing. Now he is occupied with music and arbitration for his past profession, where one arbitrator was playing in the deliberations the role of both the defaulting party's counsel and that party appointed arbitrator, where the chair decided to rescue the unbalance between the parties by totally opening up the deliberations phase based upon a detailed questionnaire that was circulated to the parties. Mark Blessing, the chair who reported the case, as I said, explains, I quote, interestingly, while the parties and arbitrator had taken the advocate's hat for the defaulting respondents, he thereafter was perfectly able to then wear an arbitrator's hat when sitting back and discussing the final decision we had to make. Professor Pierre Lalive, my mentor, and the co-founder of the firm, I was rather the co-founder with him rather than the other way around, has done the same way, where there was a leaking of the draft award to one of the parties. Faced with that situation, rather than cancel the whole proceedings, Pierre Lalive put the draft to both parties and put a series of questions to both of them, asking them to answer, and so that there was no bias possible anymore, because this was open to the parties and therefore any bias could be avoided or at least eliminated. There are surely other routes to avoid this kind of problem that is very known and in the culture, but I leave it to the panel and maybe to the floor to suggest maybe other solutions based upon their experience or their expectations. Thank you very much for your kind attention.
Thank you, Teresa. Mark, Catherine, do you have any comments?
We can't hear you, Catherine. I can't hear her.
Pardon me.
Yeah.
I think it has to happen once every conference these days. I had my mute on. So first of all, let me thank the Ukrainian Arbitration Association for hosting what's been a terrific event, and for Teresa for starting us off with such stimulating ideas and thoughts. The one kind of point I'll make to, I think, lay some groundwork going forward is that we have in many ways a linguistic problem here, the word bias. So we use it with multiple connotations, but the word itself has a lot of limitations that restrict how careful we can be in our language discussing this issue. So bias always sounds really, really bad, but and I don't want to give away too much of what I might say in my own remarks. But when Teresa talks about cognitive bias, what she's talking about, even though we use the word bias and bias sounds bad, is really in part of the human condition. And it's something that no matter how hard we would like to deny it or repress it, we are all subject to certain cognitive biases. It's part of, again, just being human. On the other hand, I think there are separate questions and behaviors that Teresa identified where bias, in a sense, becomes a form of professional misconduct, where it's a sort of an abuse of power or a misuse of power to advantage one side or the other. And even though we don't have clear linguistic divisions between these, and it gets very messy to try and start talking, try and start parsing these, and sometimes we use the word neutral or partial or impartial. But the problem with all of these terms is that they're binary, or unbiased. And you cannot really parse the different types of bias. But just in this example, in her opening remarks, I think Teresa's done a nice job of setting the scene for what would be a continuing theme in the rest of the panel, which is there are at least two categories we can talk about and are talking about. One is cognitive biases, oftentimes referred to as unconscious biases. Some of those can be, in fact, very positive. Some of those can be ones we don't know, but in fact are negative. A lot of discrimination is considered a product of unconscious bias. And that's different from or distinct from some of the kinds of bias that are considered unacceptable in adjudicators and that might be disruptive in the proceedings. I thought Teresa's examples were very interesting, including the procedures for trying to cure them. And when those examples of bias become too prominent and affect the procedures too much, they may even become a basis for challenging the award or for challenging the procedures during the procedures, disrupting the procedures, and later for challenging the award. I think with that, those are my comments on Teresa's nice opening, but Mark may have something else to add as well.
And thank you. Yes, I think it's important to keep in mind that you have different words which have different meanings. Bias is a very large one. We don't have this word in French, really. In French, we have partiality, which is something which is more restrictive than bias. So, of course, when you were taking Teresa, when you were talking about having an unanimous award in order to prevent from bias, you can have an unanimous award without having an arbitrator being biased. I mean, a dissenting opinion is not a traduction of a biased behavior. So bias is something which is very large. It is not partiality. And as you said, Catherine, it is something very interesting. It is all what we call unconscious bias, which are not partiality. Well, it can be partiality, but it is much larger. And it brings to the question of neutrality. And neutrality is a real issue which has not been very much explored in arbitration. In fact, I was asked to give an opinion on the question of neutrality and whether it could base the challenge of an award. And it's quite interesting because you don't have much things about neutrality. And so neutrality poses the question of the of the absence of any bias of any kind, and that's interesting. Something to explore, I think.
Thank you all. Before we move to the next topic, I have a question to all of you, probably to spark again our discussion. How do you think whether the current trend to discuss diversity in arbitration would have an impact on decision making? Because so it's quite clear that when the tribunal is composed of quite similar person, it's easier to agree rather than once it's composed of diverse person with diverse background, geographical, and all other aspects. So what do you think? Is it good or bad?
Just to understand your questions, what do you, I am not very familiar with, because we hear this word 10 times a day, but we are not sure it covers always the same concept. I would like to know what you imply, because when we speak about international arbitration, for sure you will have three arbitrators coming from different legal background and nationalities, culture, and more often than not language. So is that a concept of diversity that you are referring to?
It is.
Now,
Yeah, also
also,
including, so to say, yeah. So
I would personally
I would.
say that, if I may, I would personally say that it is in the context of deliberations and international arbitration tribunals. I have gone through a diverse form of diversity in the sense that we hear every day. Men towards women, people of color towards people, etc. I must confess it's difficult for me to tackle this issue. I think it's a very difficult issue. But be that as it may, I think the main, in the deliberations process, the main issue is the differences in the culture, in the cultural background, in the legal background, and much more than other form of diversity that we might refer. I just wanted to clarify, to clear the ground, as far as I am concerned, in my experience.
Mark, Catherine, anything to it?
Teresa said, in that I think really international arbitration was sort of founded on the notion that once you get into decision making at the international level, you're necessarily dealing with people from different legal cultures. And we need to have a system that can responsibly handle those differences and find justice despite these differences and taking account of these differences. And I think today we are facing what is, I think, rightly has been considered a bit of a crisis, in that the other reason why diversity is important is one of the ways that we take account of different legal cultures is by having representativeness. Not to say that arbitrators are representatives of the parties, but they provide representativeness on the tribunal. And I think as part of the decision making, and as we talk about cognitive biases or unconscious biases, that representativeness, making sure that people who are part of the dispute resolution community and who are part of individual disputes can see that their viewpoints, that their concerns are fully addressed and addressable by the tribunal, I think really is how we link the larger questions of diversity, which go to, I think, questions of fair access for people and the sort of legitimacy of the pool of arbitrators as a whole, to the individual disputes. And do we see the justice that is described as transnational as being truly something that everyone can see themselves in and see their own the representativeness of their legal cultures and interests in the decision-making process. So I think that's part of what the hard work that international arbitration has done, is working to harmonize these different legal cultures. Today, we have just, I think, a much broader range of inputs than we used to. And so a broader range, you might say, of cognitive biases that everyone wants to see being identifiable within both the community and individual tribunals.
Thank you. Mark, any comments?
No, I will simply say that I don't think that diversity makes the deliberation more difficult. In fact, I have had deliberation within a Franco-French arbitral tribunal, which were very difficult. So it does not make the deliberation more difficult, but it makes the deliberation much more interesting in my sense. So that's one thing, because you have, I mean, this diversity of culture, and that's very interesting to confront these. But and of course, if you were talking and if you were meaning the gender diversity, I would say it's absolutely essential, and of course much better to be and to deliberate with women, not only with men, if possible, at least.
Thank you. So let's move to the counsel perspective of our topic. Mark, so you are an experienced advocate and you teach the art of advocacy. Could you tell us how advocacy can influence decision-making process in arbitration?
Yeah, thank you. First of all, Olena, I want to thank, of course, the UAA for its invitation to speak, and especially Olena, of course. Again, thank you. It is an honor to represent the French Arbitration Association at your first annual conference. But let's come to my topic. So, how advocacy can influence decision-making process in arbitration? Well, to live is to choose, and to choose is to decide. In our life, every day, at every moment, we make choices, and therefore we decide constantly, even if we are not aware of it. For a long time, psychologists, I'm not talking about philosophers, were not interested in the process of making a decision. In the last 20 years, the situation has changed. Studies have multiplied, mainly in the US. You may ask, well, how can the studies on the decision-making process of mainly American juries be of interest to arbitration? Well, the reason is that in arbitration, justice is not the work of an institution, as it is in civil law countries. Arbitration is the work of individuals, as it is in Anglo-Saxon justice. Arbitrators are not attached to a specific legal. They are the actors of an embodied justice. Therefore, they are not only cognitive thinkers, they are also affective thinkers. Advocacy in arbitration shall aim to act on both cognitive and affective levels in order to win the case. Benjamin Franklin stated that if you would persuade, you must appeal to interest rather than to intellect. It is why the psychological studies conducted on decision-making in the US were very quickly of interest to the actors of arbitration. The aim is to understand in order to better anticipate the decision-making of arbitrators. Once the drivers of arbitrators' decision-making are better known, it becomes possible for counsel to adapt their argumentation to the psychology of arbitrators, to maximize the efficiency of advocacy. So I will address three questions rapidly in my speech. What is the objective of advocacy? What are these psychological drivers? And how shall advocacy interact with these drivers? First, well, the objective of advocacy in arbitration is to facilitate the role of arbitrators, of course, in their mission to judge. But what does the mission of judging entail? According to a former president of our Supreme Court, to judge means to enjoy listening, to try to understand, and to want to decide. Thus, in order to serve its purpose, advocacy must be part of the process that leads. Therefore, advocacy must serve in mirror what the judge said, I quoted, so it must serve the listening, the understanding, and the decision. That leads to one question. To serve such ends, shall advocacy aim at informing, educating, attracting, creating empathy? In fact, all of these at the same time. But one additional question then, for what ultimate purpose? To convince, to persuade, or to complete the process of convincing or persuading? Response, again, the three of these. Advocacy must successively aim at convincing and persuading. Now one needs to identify the drivers of the conviction and persuasion processes in order to influence decision-making. What are these drivers? The decision-making process is the result of both intuition and deduction, i.e. a process that combines subconscious intuition and conscious deduction. Any judge, and therefore any arbitrator, can be influenced in his decision by psychological drivers. What we call cognitive biases is what Catherine mentioned. Since the objective of advocacy is to influence decision-making, it must act on these different subconscious biases in order to predispose the arbitrators in a direction favorable to the defended thesis. So, what are the drivers of the art of persuasion? In French, we say decision. Je prends une décision. In English, we say to make a decision. This difference is where in wording it, in my sense, the English formulation better reflects the decision-making process. A decision is something that the individual shapes rather than something pre-existing that one simply perhaps takes. Because the decision is something that is shaped, advocacy shall aim at incorporating this creative process by inserting into the psyche of the arbitrators and accompanying the arbitrators in their decision-making. The Latin rhetoricians already identified the three drivers of persuasion: docere, to teach; movere, to move; delectare, to please. The vision is still relevant. It is by playing on these three drivers that advocacy will be able to act on the arbitrator's subconscious biases in order to persuade them to agree. But what are the techniques to play on these different biases? There are four. First, know your audience. Knowing your audience in arbitration is an interest in the psychology of the arbitrators. And how can advocacy force the attention of the arbitrators? By playing with the two types of information that can be transmitted to an audience: cognitive information and affective information. This leads to the question of how the information delivered by the litigant is likely to circulate in the minds of the arbitrators. Well, there are two levels of information. The surface structure, this is the interaction of the brain with the information received and transmitted by the five senses. And the deep structure, it is the interaction of the brain with the information carried by experience, values, opinions, etc. The so-called ocean test illustrates the way in which the surface structure works as opposed to the deep structure. It is easy to imagine what the surface of the water is as opposed to the depth. But how shall we dive from the surface structure to the deep structure in order to be able to interact with the deep structure, i.e. the belief level, and maximize the chances of success in not only convincing, but also persuading? That means cumulative and not alternative. The storytelling and the message. The storytelling, as you may know, there are two levels of information. There is a raw information, this is the factual data. And there is a reprocessed information, this is a narrative. And the two levels of apprehension of information address the two levels of perception of the brain. The factual data feeds the surface structure, and the narrative is the deep structure. The narrative is the story of the case. By telling a story, by giving a color to the facts, we interact with the affective process by adding it to the cognitive process. Now you have the means. You have the message. In order for storytelling to serve its purpose, it is important to distinguish between two notions: the understanding and the knowing. What is the most important thing in the art of persuading? What will enable the argument to be better registered by the arbitral tribunal in making? Well, the answer is the understanding. And understanding requires knowing the meaning, which in turn requires getting clear messages, and the whole being framed so that the meaning with the messages can be printed in the brain. So meaning, message, and frame. But is it enough to structure the storytelling to increase the chances to interact with, or on the contrary, to dismiss the cognitive biases feeding the decision-making of the arbitrators? So is it enough? The answer is no. The ultimate goal shall be to go beyond the cognitive drivers of the arbitrators to target the beautiful in order to interact with the intuition. So my last mantra will be target the beautiful. But intuition is a driver that is all the more powerful because it escapes reason. There is a formula I like which says intuitive reason is a reason that ceases to reason. It resonates. In the Kantian approach, to act on intuition is to escape from rational criteria to act on aesthetic drivers of beautiful. What is there to understand in the beauty of a rose? Precisely nothing. Beauty does not require an explanation. As the German poet wrote in the 18th century, the rose is without reason. Thus, by giving a color, storytelling must tend to provoke in the mind of the arbitrator an aesthetic judgment that will convince him or her of the beauty of the decision he or she is going to make. That's called, as Hegel said, beauty of truth. Thus, by targeting the beautiful, one targets the feeling of right and truth in the arbitrator, and one completes to persuade him or her. Last word. Dear listeners, you may think that, well, these reflections were somewhat abstract and foreign to the arbitration matter. Well, on the contrary, I believe that they are essential to this matter. Indeed, it is the aesthetic criterion that will make justice escape from automatization. You will hear Catherine about it. But which justice? Arbitral justice, precisely, and less state justice. It is because in arbitral justice, the parties will still be able to give to arbitrators attentive to their speech the color to the facts that arbitration will remain the best form of justice. Let us beware of transposing to arbitration the positive models of state justice. Doing so, arbitration will certainly lose its soul, but worse, it will lose its beauty. Thank you for your attention, and sorry for having been a little bit late.
Thank you for your comments. Catherine, Teresa, do you have something to add with your perspective?
If I may, Catherine, you want to take the floor?
No, Teresa, I think it's all you.
I am delighted with what I heard because it's exactly being on the other side of the table, namely having spoken as an arbitrator. I think you, Mark, spoke about legitimacy of a decision, be it judicial or arbitral. And legitimacy go through objective and subjective comprehension that leads to the global comprehension. A very famous philosopher in France, Morin, has published about that, and before him Kant, and before Kant Eschyle, 5th century before Christ. So I think you are, and this is so important that indeed as arbitrator we have to catch both the facts, the objective comprehension, and the subjective comprehension is core to a legitimate decision. So I cannot adhere more to what you said, and I have indeed given some conferences on that subject that is so important, because people comes with thousands of facts, thousands of paper, of letter, of email, and forget that there is a very scope to reach, which is to make to have a legitimate decision and to lead the tribunal to understand what would be the legitimacy in that regard, having both the winning and the losing party understand, in particular the losing party, and also for the winning party, because I am sure you have crossed situations where the winning party, there is never one 100% winner and 100% loser, but be that is may, the winner wants to understand why it won. It's not sufficient that he got it. He wants to know why. And this is something very important also, obviously, for the losing party. So I cannot adhere more, and I thank you very much for having tackled something so sensitive, Mark. Thank you.
Thank you, Teresa. Catherine?
I'm not sure I have anything to add to
Okay.
Mark and Teresa's comments. I thought they were quite comprehensive,
Okay.
but I'm happy to pick up to move forward.
I suggest then to move to the next topic of our discussion. So we have discussed the arbitrator's perspective, the council perspective, but there is one more interesting angle of the topic, and whether the arbitrator's past decision could have any implication or impact on his or her future appointments. And Catherine, as your founder of Arbitral Intelligence, you certainly know more than we all taken together about implication of decision making for arbitrator selections and related issues. So could you tell us about this, please?
Thank you. So since we started with arbitrators and then counsel, I think you might frame my issue as parties' biases or parties' perspectives, parties' questions about cognitive bias. I really liked, I have to say, there were so many interesting things to draw from, but one that I want to pick up on was Mark's, I would say, reframing of the term cognitive bias, which is a very loaded term, again, because we use bias to describe both very harmful types of bias, like prejudice, racial prejudice, gender prejudice, but also kind of neutral biases that he says are what we might call psychological drivers. You might also refer to cognitive biases as decision-making preferences or decision-making proclivities. If you want to be even a little more provocative, you might say these are experience. They're essentially the manifestation of our cognitive processes as a result of our legal culture, our legal training, and our personal and professional experiences. I want to start with this observation that these are incredibly important. If you wanted to have a truly neutral, a truly impartial outcome to a decision, there are ways to do it. You would flip a coin, you would roll a dice. But those, while they are completely neutral, could never be determined to be in favor of one or the other. They are not the kind of reasoning that we require. And that reasoning, in recent days, we've said, well, maybe this reasoning could still be neutral if it was a machine, if it was artificial intelligence. I don't think, and the research is showing, even artificial intelligence really cannot be truly impartial, because it's shaped by what it's fed in terms of its learning, but it also has no common sense. And in fact, I think one of the key features that we are looking for when we choose arbitrators is their ability to bring common sense, professional sense to the decision-making process. And this is essentially bringing their experience, bringing their decision-making proclivities and their own psychological drivers. That is why we want to choose, when I say we, I mean that's why parties want to choose their own arbitrators. Why? Because not only does each arbitrator have psychological drivers or cognitive biases, but each party does too. The parties, the opposing parties, oftentimes, I would say only in rare exceptions, do not see the dispute as something very different from their own perspectives. Sellers have different perspectives than buyers. Licensors have different perspectives than licensees. Purchasers have different perspectives than manufacturers. And so they're looking to appoint an arbitrator, someone who shares a sort of psychological driver, an experience, a decision-making preference that's similar to theirs. So that's why parties do want to, and oftentimes prioritize the ability to select, quote, their own, to select at least one member of the tribunal and have input on the third. But what does that mean in terms of the selection process? Well, historically, and I'll say something maybe a bit provocative here because it's a little counterintuitive. We don't choose anymore, I think, arbitrators based only on their resumes. That is, I would say, necessary, that they have good credentials, excellent education, and a lot of experience. But we don't choose them for that. We choose them instead, going back to what we said earlier, for their decision-making preferences and how well they are understood as aligning with parties. And so what does that mean for arbitrator selection? It means historically that we would choose by proxy. If you wanted plain meaning analysis, you might choose an American who uses the parole evidence rule. If you wanted very little document production, you might choose a civil law trained arbitrator. These proxies, I think, have really broken down as we see a lot more cross-pollination in these legal cultures, and so they're not really sufficient. So what came after the proxies? Personal references. We pick up the phone, we call around to our professional network, we say, how do you think they would approach this kind of a legal issue? How do you think they would approach this kind of procedural issue? And we're looking again for feedback to help us understand the experience and how it will inform the decision-making preferences. And that's important when Mark said, know your audience, okay? Part of what parties are trying to do is pick their audience so they can understand, so they make sure that they know them and know how to appeal to them. Now, the problem is, I think, a couple. One, the pool of arbitrators is expanding. Proxies are no longer sufficient. And as arbitration has grown, telephone calls, personal research is no longer as sufficient. So what is, I think, becoming increasingly important is for parties to be able to identify and reference the track record of arbitrators' past decision-making in a way to understand what their proclivities, what their experience, how that might translate into decision-making that they can then appeal to, as Mark said, through advocacy. The problem is arbitration information about arbitrators' past decision-making is like an iceberg. The number of redacted published opinions awards in international arbitration is tippy top of a very big iceberg. And in fact, that's why we call around, because those decisions, even if it's increasing, are not nearly enough. So what arbitrator intelligence tries to do is it is what you might call like sonar. It seeks to go, and we've had the water metaphor once before, it seeks to see and identify what is below the water. What are some of the patterns, in particular arbitrators' decision-making, that might help counsel and parties understand if this is an arbitrator they want to choose, or if they're preparing for the hearing, how they might frame their advocacy for that. Now, to do that, I think you need information on a lot of different topics, not all of which are in awards. So, for example, one of the most important topics parties research on is document production, because they either want and need document production to be able to prove their case, or they oftentimes want to avoid document production for efficiency or other reasons. They want to know how what the decision-making on other types of procedures, on other types of substance are. I do think in the future, we've been looking for many years, how do you balance increasing transparency, empowering parties to make more informed decisions about arbitrators they're choosing, and to make counsel have a better informed understanding of how to know their audience, how to present to those arbitrators. On the one hand, so parties crave and need this kind of transparency, but at the same time, they want the big part of the iceberg to remain under the water. We are not at a point where confidentiality is something we're willing to sacrifice for the needs. So what we do again at Arbitrator Intelligence is try to create the data analytics that provides a sort of balance between the transparency that's needed and the confidentiality that's required. The way we do it is we collect at the end of each case. We not ask the parties' names. We don't ask what the legal issues were, or what the procedural issues were, or what the factual issues. We only ask for the decision-making, kind of the outputs, so that we can then compare them. Going back to the comments that were made by Teresa earlier about the tribunal's decision-making, if you have a dissenting arbitrator, which is very, very unusual in commercial arbitration in particular, you can identify a particular outcome or decision with a particular arbitrator. But what data analytics allows you to do is if you see patterns of decision making, you see one arbitrator who, in the vast majority of cases in which this person has sat, they have more document production than another arbitrator. You can't attribute that decision necessarily to that one arbitrator, but you might think that you have a better chance, or you're more likely to have, if you have this arbitrator on a tribunal, a chance to argue in favor of that, or if you want to avoid it. So data analytics will never essentially open the arbitrator's mind and describe to you in detail what their cognitive biases are, their decision-making preferences, their psychological drivers. But it can give you hints that are extremely important when, as an advocate, you need to know your audience, when, as a party, you want to know who to pick as an arbitrator. Thank you.
Thank you, Catherine. That was really interesting. I don't know if Teresa and Mark have something to add, because it's very, very specific topic.
Mark first. Diversity.
No, I mean, arbitrator intelligence is a very interesting topic. I must say that I am cautious about it because, as I said, my fear is to have the positivist models integrated in arbitration, and it is not what I want for arbitration. It is, for me, in fact, arbitrator intelligence, what, if I understand well, could permit to associate a certain type of decision to a man, to a woman, and to an arbitrator. And and in fact, for me, it's not what arbitration should tend, because arbitration for me is is the classic way to render justice, in the Greek way, which means that justice is rendered out of the dialogue, which means that each time you have a deliberation, you start from zero. And I don't want to have taking the model of what state justice is. And that's why I think it may be a very interesting tool, but I think that we must be cautious, because, as I said, I don't want to have arbitration losing its soul, because of that, because of this dialogue aspect. That's my observation. Very general.
Can I offer just a quick clarification?
Yeah, please.
Maybe if I can clarify, and maybe it also perhaps addresses at least what you wanted to say, Teresa. So I do think, one of the, just to clarify, what is sometimes a common misunderstanding, and there are people who are working to do this, but arbitrator intelligence does not seek predictive analytics. So predictive analytics is when you ascribe to future behavior. You say, well, we think the outcome in this arbitration is more likely to be X than Y if you choose this arbitrator. Some of that's done with jury selection in the United States. In the United States and in some other jurisdictions, there is a great deal of what's called predictive analytics. It's a process of taking all the different sources of information about past decision making and trying to predict what will be done in the future. I don't think in international arbitration, even with the information that arbitrator intelligence is bringing together, that it's really anytime possible in the near future to do responsible predictive analytics. And I think if you can't do it responsibly, you should not do it. I do think, though, what we do is much more is much more akin to the kind of phone calls that are currently going on. So we're not doing anything that doesn't already exist. We are just collecting it more systematically and making it available to everyone. Because right now, how you collect the kinds of information we collect is by phone calls, which may work very well if you are a big law firm with a huge network of people to call, okay? But that's not how we should determine who has information and who's not, right? Especially as we're seeing, and this is particularly relevant in an arbitration event seated in Ukraine, we are seeing some amazing regional law firms taking on very big cases. And they shouldn't be at an informational disadvantage because they have a smaller network to research through. And so what we do is we collect the same kinds of information, again, just more systematically, and making it available to everyone equally, as opposed to based on personal relationships. Not that there aren't risks, and not that there aren't challenges. I have always understood this because it started as a research project. And as you know, my area of research is ethics. So I've always thought we need to be very careful about this. But I don't think those risks distort the process. So that was the one clarification I wanted to add.
Thank you. Teresa, would you
If
like to?
if I may, I have rather questions. Obviously, I am aware of Catherine research and so challenging, interesting, and I always wondered how she could manage in such a world where, for instance, you said something, and it is a question for you. I always wondered when trying to follow I have read most of what you have written, in particular on ethics, but on arbitrator intelligence, as you just explained, you said, correct me if I'm wrong, identify arbitrators' past decision making, correct? And at the same time, you say, quite rightly so, in my view, that it's very difficult when we have a three-member tribunals to know, to attribute to one or the other of the arbitrator the prevailing view that at the end is the subject matter of the award. So I think it's very, very difficult. And at the same time, I remember having not hired, but chosen, selected, and recommended to one of my clients an arbitrator for what he had written on the legal issue at stake, and he decided exactly the opposite in the award. But true it is that there were three. So, and when you mention, Mark and you, the issue of dissenting, I mean, most of the dissent you don't see. What you can see is what I mentioned. You have a full liability recognition in the award, and you have a damage claim which is 10% of what was asked, without real explanation. And it is the result of what I said, the bargaining. I would like to put an end note, because I would like not to take the time to other to the participants and to other people. But what I would like also to say is that I was not mentioning, I am not talking, I fully agree with the fact that biases might not be the right word, because it has a sort of connotation of misconduct, which I thought set aside in saying that it is not the more interesting of the bias. It's rather the question of cognition, of different cognition, or I don't remember the exact name you use, but bias has a negative sound, which I must say not only doesn't interest me so much, but in addition is not the main one. I never, or almost never, met this kind of bias. Conversely, I met this kind of bias I mentioned, that one of the arbitrators considers himself or herself as having been appointed to defend the thesis of the party having appointed him or her, and arguing the case in the tribunal, which is very difficult. And at the end, the result is what I said, is a sort of compromise, while the tribunal is not called to decide ex aequo in bono, but rather under a certain set of laws or rules. Well, thank you for your attention. That's what I wanted to. But it's a very interesting panel. I would like to have a full day on these subjects with Olena as moderator, but also as speaker, because these are so important and so sensitive issues, and I can see that all of us are quite concerned. Olena, I must say your selection, at least for the other two, was perfect.
Thank you. Thank you, Teresa. So I have just received a message from Justice Spilikov. Unfortunately, his hearing is still going on and will continue tomorrow. So he asked to beg the pardon and apologize for his inability to join our discussion. However, we have some more time. And we have time for questions. We have received several questions from the audience, and the first question comes from Janina Vlasenko from Spain. Do you think that it is better for an arbitration lawyer to have some additional education in management in order to improve the decision making? So,
In
additional
management.
education in management. I would add that probably something else, but let's start with management. Yeah. Do you think the additional education would be helpful?
Additional education is always helpful in any case, but I'm not sure to understand what means management in that context. Maybe she can explain.
Some business school, you know.
So, like you did it, Mark? Did you?
No,
you
no,
have
I
a
did
business
not.
sort of.
I have a master in economics and law, but not
Economy, yeah.
Well, it's not bad to have it. I would say it certainly can serve, but I don't think it's absolute. I don't think it is necessary for sure. But of course, I mean, we have more and more double, double masters. So and MBA plus a master in law. So yes, I mean, of course, it's good. I mean, it can be, but it's absolutely not necessary. I know, frankly, many of the most well-known corporate lawyers in Paris do not have an MBA or have a business school, so it's not necessary.
I might add one point of view that I agree it's not necessary, but maybe this is what the person who asked the question was getting at. One thing that when they have surveyed in the United States, at least general counsel, not in arbitration, and really just a general survey of general counsel, and they said, what is the most quality you want in a lawyer? And when I hear this from someone who educates, a range of ideas in my mind, but the one thing they said that was most important is they want a lawyer who understands their business, and that was not anywhere on my list. But I do think that clients, parties want someone who understands their business. So I guess that might be one way to interpret the question is, would business school perhaps help you understand at a deeper level the actual business transactions underlying the dispute in a way that might be appealing to the parties? So I don't know if that's necessarily what was being asked, but as lawyers, sometimes we do forget, the business interests of the parties, which of course is part of, why they go to arbitration. So I don't know if you need a degree to do that, but I would say it's certainly the business side is important for the parties in choosing probably an arbitrator.
Thank you. Yeah, Mark?
No, sorry, I fully agree with Catherine. In fact, we need to be business-minded to be a good arbitrator. We need to understand business.
If I may, I would add economy.
Yeah, economy. It's more global. You are right. It's more global. It's in business. And that what we don't have, well, that sometimes it lacks in before state judges. Well, it's good to have to be economically minded.
Okay, thank you. We have also several questions from Vitaly Kravchenko. I will take the liberty to pick up one in the interest of time. It's a question to Mark, but probably Teresa and Catherine would like to join. What do you suggest for a council to oh no, not that one. Do you have any suggestions for the council in terms of strategy when there is a reason to believe that an arbitrator is biased?
Well, what would be the strategy for a council?
If I may, while Mark is thinking, may I, Mark?
Yeah.
I think I would exactly advise what I have mentioned in my short intervention, is that if I am faced with this kind of perception, I would ask for a listing of the, I mean, I would use the tools I mentioned and say the parties, my client would be interested in discussing the issues to be decided and to share the sort of decision tree with the parties, so that, I mean, I would use these kind of tools to limit the damage that can create within the deliberations of the tribunal. So that's what I would do, and I actually did. Candidly, you know, saying not not looking at all, being aware of what is going on, but it's quite easy to identify the unexperienced bias arbitrator. It's more difficult for the experienced bias arbitrator.
Okay.
Yeah.
But
I
Mark,
don't think,
sorry, I
yeah.
took the floor.
No, no,
It was your turn.
it's interesting. I'm not sure I have a very, frankly, a tool. If I understand that one of the arbitrator is biased, well, I think I will ignore it and I will concentrate on the president to try to convince him. And I will. It's difficult, you know. You cannot ignore him completely. So you must do with it. I'm not sure there is. I mean, of course, again, there is what Teresa proposed, which is interesting, but otherwise, I will very much on the president.
Okay, another question from Vitali concerns the useful sources of literature. So what do you suggest for a counsel to read in order to learn how to influence an arbitration panel? So any reference?
Catherine is a specialist, but there are several very good books in the US about advocacy, the art of advocacy, and articles about the various psychological biases, drivers, etc., etc. So, but there are some books, and I think there is something like the art of advocacy. But Catherine, you may know.
So there are great. I don't teach advocacy except in the context of the VSU, so I'm not comment on the articles. But I guess, and a bit cheeky, and I apologize for the shameless plug, but I think you should read our reports, which I think will tell you. They won't tell you how the arbitrator is going to rule, but they'll tell you how, in more cases than you could collect by phone calls. And I think this goes back a little bit to Teresa's point that it's not that that you can say, okay, well, I know the arbitrator's been in 5 cases. I'm going to, in a sense, assume away the merits of this case. Of course, every decision is influenced both by their co-arbitrators and the merits of the case. But at the same time, if you see a much higher proclivity among tribunals on which an arbitrator has sat to do one thing instead of the other, it seems to me that would be a very relevant thing to read as an advocate, to understand where some of the kind of soft spots might be, where there might be room to leverage or maximize your ability to affect sort of the outcome or the decision making on the tribunal. But I really think that's a great topic, great questions. But I think it's really a whole Mark. I know he does give a whole course on this, and I think it's hard to probably say in just a few words, kind of what the best techniques or the best readings on that are. Mark, you probably have written some things on this that you should recommend.
Excuse me?
I said you've put some things on this that you should be recommending.
Yeah. In fact, well, you have this Nobel Prize, which is not exactly on advocacy, but more on the psychological drivers and how which is very interesting. I mean, it's a book which is very well known in the US. I don't remember the name exactly. I was looking for it.
It's called the Kahneman is the name of the Nobel Prize winner, and it's Fast Thinking, Slow Thinking, and then a subtitle. I don't know.
Yes. Okay.
Yeah. This is quite famous book.
Yeah. And
and
it's very interesting.
Yeah. So the time is flying, and with this, we need to conclude our session. So I would like to thank you all for your very interesting presentation and comments, very insightful, very thought-provocative. I hope our participants have enjoyed our session. So thank you very much.